Pledge the flag, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay, tonight's agenda will be a bit different than ordinary because we do have a public hearing, and we also have another resolution to review the nuisance property issue on Lord Howe Street, which backs up the first portion of public participation. I believe Mr. Fuller will be joining us momentarily. We're going to open the review on the nuisance property located at 163 Lord Howe Street. I believe Chief Johns, Mr. Palmer, our dog control officer, and Mr. Ball, our codes officer, code enforcement officer, will all be testifying. They all have pertinent information to be given, and that will be the first portion of this proceeding. Chief Johns, if you'd like to begin, or would you rather wait for Mr. Fuller to be here?
That's your decision, Supervisor.
Might be better if we wait for Mr. Fuller to return, just so that we have him present and we don't do anything outside the scope of the law.
Would you like me to go arrest him?
That would be a good idea.
Okay.
Handcuff him and get him in here. Welcome. Okay. We waited for your presence to be here so we don't get outside the bounds of your expertise. Chief Johns, if you'd care to begin.
Okay, I provided to the town board just a memo that includes the New York State penal law definition for disorderly conduct. The nuisance property law of 2011 accumulates points under one section. It's 6 points per violation for founded complaints of disorderly conduct at premise in Ticonderoga. Now, in review of the records of the Ticonderoga Police Department, for which I am a custodian of records, and I'm familiar with incidents that land officers investigate and complaints that they respond to. I did find in the last 1 month period 2 incidents of disorderly conduct at a premise located at 163 Lord Howe Street. I provided you with a brief scenario of those two disorderly conduct incidents, but I think what is more pertinent is the depositions that were provided by civilians, people who do not live there, just people who observed the incidents going on at that location. They're very brief, and I would just like to read from those actual police documents. These are sworn depositions that the civilians have filed about what they've observed at 163 Lord Howe Street. The first one, and for the purpose of this hearing, I did redact the names of the people involved because they are current police investigations and pending prosecutions, but they will clearly demonstrate that there were 2 incidents of disorderly conduct at that premise. The first one was July 20th, 2014 at 1:10 p.m. This afternoon at about 12:30, I heard shouting and yelling coming from outside in front of my residence. I came around to the front of my house and observed a male, whom I later was advised was person D, arguing with a woman across the road. The woman was telling him that she wanted her purse and he refused to give it to her. I watched him throw her around the porch by her hair and also choked her with both his hands while she was on the porch around her neck. He also choked her with both his hands in the yard while they were arguing by the car. At one point, the woman was trying to leave, and we followed her down the sidewalk to the road, continuing to argue with her. I I ran inside the house and called dispatch. That is the first incident which I believe is clearly disorderly conduct that occurred at that location. The second one was on July 7th, 2014. This occurred at 10:30 a.m. I was sitting on my front porch with my 6-year-old granddaughter on 7/7/14 when diagonally across the street at 163 Lord Howe Street at about 10:30 a.m., a guy I know as being the person A came out of 163 Lord Howe. He began yelling very loudly at someone, "Come on, let's get the bleep out of here. We're going to get arrested in someone else's mother bleeping house." Person A was yelling towards the house at 163 Lord Howe Street. A couple seconds later, a white female with blonde hair came out of the house and went right back in. A couple of seconds later, as person A was getting into his car, another guy exited the house at 163 Lord Howe Street and began yelling loudly at him. "You better get the bleep out of here. You come to my house and don't bleep and pay me." The second guy then said, "I'll call your bleeping doctor. I'll call your doctor. Watch him." The second guy I know they call person B. I don't know if person B lives there or not. His sister owns a house. Her name is person C. While they were yelling, I told them to watch their mouth because my 6-year-old granddaughter was with me. In just 1 month's time, we had those two disorderly conduct complaints that did occur at 163 Lord Howe Street, and that's the only testimony I have.
Thank you, Chief Judge. Mr. Palmer?
I've been there on several times for different calls on dog calls. I have 7 down on the books since April. I had 2 right in June. And in June, I finally issued a ticket for a loose dog. So there's been numerous complaints there. Some of the neighbors, I even have, one of them on the ticket was even got a deposition written up for the loose dog because it's, that was at least the 3rd time I've been there, the dog was loose. So I have it from April till August 7th was the last time I had a call for there. So there were 7 calls in that time period for that one location.
Thank you.
Now, can I have a question?
Sure.
Do they assess a point value in terms of the nuisance law as far as dog control complaints? Are they factored into the?
Would you like me to answer that?
Or is that?
Go ahead.
Yes, local laws for animal control do accrue points at 3 points apiece.
Okay.
Disorderly conduct is a 6-point violation. Found that animal control complaints are a 3-point violation.
Thank you, Chief.
Mr. Ball?
Well, the last garbage complaint, we filed a order to remedy May the 1st, and it's been going on since then. I've issued 2 appearance tickets, and most recently we put a stop work order on it this morning because they were burying regular household garbage on the property, and the local law, number 5 of 2003, we believe states you can't do that. You cannot deposit or accumulate more or cause to be thrown on any property in the town. We had a health board hearing last week, I think it was Wednesday.
Yes.
And at that time, the board, the owner was instructed to have all the garbage removed by today.
I'd like to note for the record that part of the order that was issued was an agreement with the owner to allow them to utilize the transfer station with no payment due for 90 days on the garbage that was there. All right, now with the testimony being given, we'll open the process up. Is there anyone else that would like to speak in regards to this complaint?
The garbage complaint?
Pardon?
The garbage complaint?
The garbage and the nuisance calls, the garbage is part of the nuisance calls. How many, I have one more question. Bill, how many times have you been to the property since the 1st of May when you delivered that first citation?
Probably twice a week.
Okay, so if you're looking at 10 weeks,
Yeah. Well, we did get a complaint about someone living in a trailer on the lot too. So we do several visits for that too. And we should have ordered to remedy that also.
okay, so we're looking at 20 visits, basically. And they are part of the nuisance issue also, Chief Johnson?
Local law violations and code issues, I believe they were assessed 3 points.
3 points each. So you've got another 20 issues at 3 points each.
60.
So there's 60 points from codes, there's 21 points from dog control, and there's 12 points from the police department, for a total of 92 points since April.
I have, can I ask a question?
Sure.
I wasn't able to make the meeting, the original hearing that they had, but what is the stakes here? I mean, is removing the CO, certificate of occupancy, or?
Up
to that. Up to that, okay.
Yeah.
But there's nothing in particular right now, it's up to that point.
You have the right to assess the penalty up to revoking the CO.
I see.
So anything under that, you can condition, I've had all sorts of, just last month, or just a couple weeks ago, did a 30-day conditional, that if there were any other violations within that time frame, the landlord was trying to evict the tenants and was going to cite the nuisance process as part of the reason it was a tenant that was causing the issue. That's usually somewhat persuasive with a judge when you go in, when you're under a conditional nuisance violation. We've done them, 60-day conditionals. Also a 6-month conditional, that depending on the scope of the violation. So there's, anything under, that would be up to and including revocation if you did less than revocation.
Okay,
Is it owner occupied? Is the owner,
Anything.
does the owner live on the premises here, in this case?
the owner's here.
Okay.
She'd like to answer that.
I've been instructed by Julie Garcia that I hired an attorney and that I'm not saying anything else until I meet with her.
Okay. Thank you.
For the board's information, Mr. Fuller, could you reread the penalty section or refresh our memory of the penalty section? What alternatives are available if we so decide?
For some reason, this isn't connecting for me. I have to run upstairs, so get it out of time, so.
I think we got a copy.
This is not connecting to my network. It's a problem when you rely on a computer.
Can I-
Penalties for offenses. All right, hold on. Somebody was asking about the sections of law that come under this. That is in section 62-2B of the local law. It lists out 6-point violations for the penal law, different social services, things like that, and 3-point violations for litter, junkyards, noise, codes, is under there, fire prevention. So those are your 6 and 3. The powers to suspend, to order the closing of the building, structure, or place to the extent necessary to abate the nuisance, or to suspend for a period not to exceed 6 months, or to revoke for a period of 1 year a certificate of occupancy issued for such premises, and to prevent the operator from obtaining a new certificate of occupancy for another location for the period of suspension or revocation, or to suspend for a period not to exceed 6 months, or to revoke for a period of 1 year any occupational license or permit issued by the town related to business or trade at the premises, which suspension or revocation shall also apply to any other location operated by the holder for which the license or permit is required. That would be more towards if there were a business or something going on there that was causing the nuisance. D, the imposition of a fine not to exceed $1,000 upon the owner, lessor, or lessee of the building, structure, or place where the nuisance is found to have occurred. So you can assess a fine. E, any action necessary to abate the nuisance, including but not limited to cleaning, painting, repairing, or demolishing any building, structure, or place. Cost of any such remedy shall constitute a property tax lien against the property upon which the remedy is applied, or F, any combination of the above. So as I said, you've got, any host of, how many units are there? Is it just single?
Single unit. Question from our side of this. Since the owners retain counsel and doesn't wish to speak at this hearing, do we have an obligation to call another hearing, or can we still act now?
Oh, no, you could act. The public hearing was set, it was duly noticed. If you wanted to, you can table it, you can conditionally table it. If you wanted the property owner the opportunity to be heard with counsel, you could conditionally table it to, I'm not saying you should or shouldn't, I'm saying you can conditionally table it, we've done that. We've also conditionally tabled it subject to if there is, another violation prior to the tabling of the hearing, then the supervisor would be empowered to issue the order, revoking the CO or anything along those lines. Again, anything short of that, or assessing the fine, or whatever the board's pleasure is. The one thing I would say too is just a call on a codes issue in and of itself may not be a point. It would be the assessment of the point for what was found there. So, again, if there was trash, litter, things like that that have been there day after day after day, under that local law, each day, week can be another violation. So that's what the points would kick up, not necessarily a phone call.
In other words, you could assess points for every day from the 1st of May when the first citation was issued.
If the person was cited in that manner, yes.
They were cited the 1st of May for that condition. So for every day following that the condition exists, they would accumulate points?
They could.
3 points a day.
I just don't want you to rely solely on a phone call.
No, this is on, these are on visits. Visits to the site.
Yeah. And what I would do, it goes towards mitigation of the issue. Did the property owner take steps to mitigate the nuisance? Yes or no? That's where that would come in, I think, to your analysis. Because at some point it becomes somewhat willful.
What is the status of the cleanup right now? They were supposed to be finished by noon today.
This morning, it was discovered there was an excavator on site, and the owner and several other people were attempting to bury garbage on site,
Even
Which
though
is
they
a-
could have disposed of.
which is clearly a violation of the law that Mr. Ball explained to them. And even though they had been offered the opportunity to use the landfill with an extended period of time to pay for the cost of it and dispose of it in a proper and lawful manner.
Have they taken anything to the landfill?
I can't answer that. I don't know.
As far as the nuisance, as far as the annoyance, fighting on the porch and whatnot, have they taken any steps to straighten that out? I mean, or is there, don't know.
It's been an ongoing issue. I don't know that, there hasn't been an incident since the 20th of July.
20th was the last day we made an arrest of application.
What does it mean an arrest?
Yes, if someone was seen children, the officers were arrested.
Since you've made no visits since then?
No, as I said, we particularly law.
Okay. But have you been called there for anything?
Not familiar with it, but just serving paperwork, et cetera.
Okay.
Any questions?
Not really.
I am, with the amount of time that the owners had to deal with this situation, and the very fact that today, to me, very deliberate efforts to avoid the law and illegally dispose of that stuff, it does not lend me to be particularly sympathetic. I would be of the opinion that I realize that the owner has the right to counsel and they can appeal our decision. Would that be the case, or how would that work?
It would be in Article 78.
They would have to bring an Article 78 against the town. Okay. And then we would have to defend that in Supreme Court.
Okay. Do you want to take a brief,
Yeah.
quick executive?
Yes. I would.
Okay.
I've got it.
If we could ask you folks to step outside for just a
We've
few
got a
minutes.
motion, we've got it.
I will.
You're just temporarily adjourning the public portion of the meeting to get legal advice. It's not technically executive. So somebody make that motion.
I'll second.
Moved by Mr. Taylor, second by Ms. Van Wert. All in favor?
Aye.
Opposed? Okay, if we could ask you folks to just step out into the hall. All righty, we're back in regular session. And after discussion with our council, it is the opinion of the board that we will table this proceeding until the 28th of August, which is our financial meeting, which will be held at 11:30? 11:30 in the morning. And this will give the owner of the property a chance to meet with her counsel and be represented by her counsel at that meeting. And any penalties that are going to be assessed will be brought up at that meeting. It would be our strongest recommendation that the owner correct the issues prior to that meeting, not 2 minutes after, 2 minutes before. This has gone on way too long.
Move we table it?
Yeah, we need a motion to table. Accept the motion to table. Made by Fred,
I'll second.
We can table it to a date certain.
Yeah, so it specifically needs to say that you're tabling that till the 28th.
To the 28th at 11:30.
I'm sorry, the first and second.
Mr. Huntsman and Mr. Taylor. Any further discussion? All in favor?
Aye.
Opposed? I'd like to thank everybody for their participation and their understanding. Pardon?
Thanks.
Table, it's table, we can't talk about it.
Yeah, if it's tabled, it's done, right? We don't talk about it until next week.
Yeah, it's tabled on the 28th. Was that on this?
You want to talk?
Oh,
A little bit, some of it is, yes.
it would be tabled to the 28th, because you just
Table till the
tabled that
28th.
hearing.
That's,
Oh, yeah.
yeah, I think it's tabled till the 28th. You know, we really can't discuss it until the 28th. The next item on the agenda is to amend a local law, Local Law 3 of 2007. I believe everyone has been given a description of that. You want to give a brief explanation?
Oh, yeah. So we've been working on whether we were going to have a certificate of occupancy change required for non-owner occupied one and two family dwellings. Multiple family dwellings are already regulated. As the board debated this and the Public Safety Committee debated it for a number of months, it was decided that what the town was really looking for was inspections of non-owner occupied single and two family dwellings. So we drafted a revised, a local law amendment for that. And what it does is it's local law 3 of 2007, section 11A3, that will now read as follows. Fire safety and property maintenance inspections of all multiple dwellings and all non-owner occupied one and two family dwellings, not included in paragraphs 1 or 2 of the subdivision, and all non-residential buildings, structures, uses, and occupancies not included in paragraphs 1 or 2 of the subdivision shall be performed at least once every 36 months. So what does that mean? That means that in addition to all multiple dwellings, which is 3 or greater, all non-owner occupied 1 and 2 family dwellings will have that same inspection. Fire and safety, and Bill could comment on that if you want, but it'll have that same inspection requirement at least once every 36 months. So that was what the Public Safety Committee and the board had settled on as their real goal with regard to those properties. And it was really the status of non-owner occupied residential units and structures have become an issue, and inspections is the way to handle those, to bring them into compliance. So the board has a public hearing tonight, and after that, a review of the local law.
I got a question for Mr. Ball. Is that okay to ask?
Yeah.
Bill, as far as the fee for these fire inspections, have you arrived at that, or is that part of your schedule already?
Right now, it's $25.
It's $25. And are you going to have adequate staffing with the people you've got on the payroll right now to do this, to accomplish this extra work? Okay.
So is that, if it's a 4-unit building, is it $25 per unit or for the whole building?
But right now, if we do it all at the same time, it's $25. If we have to go back, every time we go back, it's another $25. So the landlord on multiple dwellings, we set an appointment where the landlord can get into all the apartments and we can do the inspection. Again, that's going to be entirely up to you guys, what you want. If you want to charge a fee, how much you want to do it. Again, like I've always said, I don't make the policy, I just follow your rules. This is definitely something that I've been pushing for. Wayne Wagner, this has been going on for years, not months.
And how about if you have to go back to inspect a violation? Did that,
Well, if there's a violation, then it stays open, and we'll go back as many times as we have to do it.
well, at one time there was discussion about assessing another fee if they
Yeah.
didn't correct the violation. So is that in the?
You don't do that by local law, that's just part of your fee schedule.
Oh, okay.
So you can have that discussion after consideration of the local law if you want. Yeah, you talked about having an initial fee and then if there were a checklist or violations that Bill identified, possibly having one re-inspection included in that first one. And if there was anything after that, then it would be double or triple the cost, some escalating number. It would be in the board's discretion to do that.
Bill, but some of this particular stuff that you'd be looking for, I mean, is it like signage, exit, not an exit, emergency lights? Is there any dispensation given for an older dwellings, or is this?
In the property maintenance law, we have residential inspections. They're not anything like a new building inspection.
Okay, that's it.
But, yeah, we have a list of them. And we've also got lists from other municipalities. And again, if this passes tonight at the next committee meeting, I'll bring a couple of them in and they can go over it. But it's strictly safety items.
I see.
Smoke alarm, carbon monoxide detectors, escape windows working, stairways are safe, handrails on the stairs.
Okay, I see. Piping for oil tanks?
Yeah.
Black iron, no PVC, stuff like that? Okay. Good. As far as,
Just so you know, Wayne, there's two issues in your question, okay? One is what has been grandfathered by the code,
yeah,
and the other is what changes had to be made to make your property into a commercial entity.
Okay.
Now, if if the owners have not kept up with the regulations that they needed to, then it would be an issue, a violation, okay? If they've kept up with the issues they were required to by law, there are other issues in the code for new construction that do not retroact on
so
old
basically what we're
construction.
enacting this, we're going to have a specific trigger. Every 3 years, it's going to be looked at. I mean,
Well, at least every 3 years.
At least
at least,
If it's not an issue, we can inspect it every 6 months.
or if there's a fire, probably a structural problem or something.
Yeah, or complaint, whatever.
Okay.
It gives Bill the access to the buildings that he should have.
I see.
So-
Makes sense.
Just a little clarification, are we required to do it every 36 months, or do we have the right to do it every 36
We're
months?
required.
We're going to be
Shall.
Required,
Yeah, we're required, not more.
not more often than that,
No, not less often.
not less often than
We can do it
Shall.
more often, but we can't do it.
that. So we can't,
You couldn't do it once every 5 years.
that wouldn't, so we'd be in violation. And you're confident we can handle that?
Well, there's 2 people going through the code school right now.
Okay.
Any other questions? Comments? We need to hold a full public hearing.
You have it scheduled for tonight? You can open the public hearing.
Okay. Are we considering this?
This is your
Yeah.
public.
This is a public hearing. Okay, if there's no further comments on the issue, we'll close this public hearing. We've got one more to go. And we have another public hearing that has been tabled. It could be reopened tonight. I can tell you that we'll open the public hearing for Coast Point Board of Health Sanitary Code investigation. And I'm going to open it by stating that all the dye tests except for one have been performed. We do not yet have any positive test results, which is not a bad thing, that's a good thing. But it's still, because of the way dye tests work in a septic, it's still very early in the game to know how this is going to play out. And I would recommend that we table it again for tonight, bring it up at our next hearing,
So
or our next meeting.
once they,
The next regular meeting, I'm sorry.
Next regular meeting.
once they do, I've never participated in a dye test, do they go back every day and look, or how often?
Nearly every day, but it doesn't have to be every single day. The dye is very strong. And if the systems fail, it may take 30 days, it may even take 60 days for that dye to show. If the fields are working, that dye will never show. But it may take some time for it to work to the surface, and you give it that time.
And once that dye shows, it'll be there for a few days.
It will stay for
Jerry,
a long time.
the neighbor Jerry Abbott was part of the village when they put that in, that water system up at Baldwin, and he said they had to do something similar. And the rate at which the dye came in was so solid, so slow, they had to look at it from an elevation, when they had to fly over it, had to do a flyover to see it. You know,
Interesting.
so, yeah.
But
That's what he said.
I would entertain a motion to table this hearing for our next regular meeting, which is September something,
I so moved.
September
11.
11.
I'll second.
Thank you, Jen. Made by Mr. Diller, second by Mr. Huntston. All in favor?
Aye.
Opposed? Carried. Okay, now we can go back to the agenda, and we will open it up. If anyone from the public has something they want to bring up, we would entertain that. Mr. Barnhart?
Good evening. My name is Bill Barnhart. I'd like to read a prepared statement, please. I reside at 49 Amherst Avenue. My family and I have lived at this residence for the past 23 years. I would like to address the board regarding the possible relocation of the police department from its current location to the Armory outbuilding located almost directly across from my residence. I would also like to go on record that I am an ardent supporter of our police department, so I do not consider this to be a police department issue at all. In my former position, I had frequent contact with the police and always found them to be both helpful and professional. I am also well aware of the situation with the current police building and the financial constraints that the town is facing. As a taxpayer, I applaud the board's efforts to keep taxes in check while providing exceptional services. As they say, no good deed goes unpunished. I would also like to thank the supervisor and board members that I have talked with for their courtesy and professionalism. I know this is not an easy job, and I thank you for your service. My concerns with locating the police station in the Armory outbuilding are as follows. First, increased traffic. With schools located at both ends of the street, buses in the morning and afternoon, and at other times as well, do we really want our officers heading out on a call from this location? They could literally find themselves blocked on Amherst Avenue as a means of egress. Saturday evenings and Sunday mornings are especially worrisome, as there are services at St. Mary's which would most definitely block or at least hinder egress. Point 2, increased noise level. This is mostly a very quiet residential area outside of the school bus periods. A very quiet street during the summer months. The current police station is in an area where this noise is minimized. Number 3, safety concerns. There is a lot of vehicle traffic and foot traffic at the Armory, especially during the school year. Egress onto both Amherst and Champlain could be very dangerous as children walk to the Armory for after-school programs. There are some very tight turns coming out of that location, especially as you egress towards Champlain Avenue. Another concern is resident safety. Has a detainee ever escaped from the station? Would we want this to occur in this area, especially with the close proximity of the schools? Number 4, decreased residential property values. I would demand a lowering of my assessment, and I am sure others on Amherst and adjacent areas would demand the same. I have talked with several experts, and they all agree that property values would decrease. Do we really want to shrink our tax base? Number 5, this is just not a good location. Do we really want our police department hidden away in a residential area? Ideally, I believe the police department should be in a highly visible area. We want visitors to our town to have quick and easy access to the police. We want people who need to talk to the police to have a location that they feel secure in, away from the general public. A residential area does not provide this. We want businesses to feel secure. Having the police hidden away in a residential area does not provide this. I have always been told that I should not voice concerns without offering solutions. I am sure you have looked at some, if not all of these, but here we go anyway. Number 1, do nothing. Although the current building is not ideal, it is still a better option than moving it to a residential area. Number 2, combine with other services, either the fire department, emergency services, or town highway department. Number 3, look again at vacant locations and more viable locations such as the old Rite Aid building. Number 4, seek funding through grants. As a former grant writer, I would be happy to assist you in any way possible. In conclusion, I would like to thank you for giving me the time to voice my concerns, and I'm hoping that I will hear soon that you are moving in a good direction. I have copies of the letter if I could leave them with you. Thank you.
Yes. Bill, I want to thank you for your comments. I can tell you that there have been preliminary, very preliminary discussions about that building. At this point in time, there is no plan to move. It has been discussed. We need to have the building assessed by professionals. If any action is going to be taken by the board, it would obviously be subject to a public hearing to get input from everybody in town. That's where we stand with it right now. You're welcome. Anybody else have anything they'd like to bring forward? Yes, ma'am.
My name's Holly Dixon, and I live across the street from Bill at 54 Amherst Avenue.
Okay.
And I would like to express my shared concerns with Bill about this possibility. Actually, all of his sentiments, I think I share them. And I'd like to thank him also for his letter and you for and effort on behalf of this. I'm very concerned also about possible stress on the neighborhood if this happens, and also on the children that are very walking back and forth in that area at all times of day. And just as again something that I was Googling today, and I was on Google Maps, and this is probably something that people have already done. But really, if you look at the satellite Google map and the difference in the location of the police department where it is now, and then you asked, and then you Google mapped on the armory in Ticonderoga, you can see really clearly that it's much, the armory is located very deeply inside a residential neighborhood, where the police department currently is located is further away. That's just.
I would just like to tell people that when and if the time comes, I'm not going to vote for any proposition that's going to hurt anybody or demean anybody, because we have a whole litany of different options. We did some studies back 2006, 2007. We had a whole list of viable places, that we'll vet. And again, it's going to require capital, which there's no provision for in this year's budget, and it's going to be really doubtful for next year's budget, from where I sit.
Thank you very much.
Thank you. Anyone else have anything they'd like to bring forward? If not, we'll zip through our resolutions here and get to our reports as quickly as possible. I'd entertain a motion to accept the minutes, the regular and special meetings.
I'll make that motion.
Moved by Mr. Huntsman,
I'll
Second by
but-
Mr. Taylor.
Tanya, which one do I have to abstain from? Is
You have
that,
to abstain from the August 5th, the public hearing for the local laws and Board of Health on Myers and Board of Health.
okay. Can I second the
So you
motion?
can- So you can do the regular town board meeting, which was held on July 10th, and the monthly financial meeting held on July 29th. You all can do, you all can do two meetings. And then we can do a separate one for just that one, you can abstain.
Okay.
Or you can abstain all, just do this once.
Maybe I better do that. So I can't offer a second then, right?
If we're just doing the two,
Okay, all
if
right.
that's what Fred's resolution is.
So the motion, well, it would be all the meetings between now and then. And then just,
I
Mr.
abstain.
Taylor's going to abstain from the,
Yeah.
So Fred brought a motion to accept all the minutes of all the prior
yeah,
meetings.
I'll second that.
Chad seconds. All in favor?
Aye.
Opposed?
I abstain.
From domestic. Approval of the water and sewer reports, you have a copy of those? Entertain a motion?
No.
Mr. Huntston,
I'll second.
second by Chatty. All in favor?
Aye.
Opposed? Thank you. Approval of the supervisor's monthly financial report. You have an attachment for that.
I'll move that we accept it.
Motion, second. Discussion. All in favor?
Aye.
Opposed? Entertain a motion to pay the bills.
I'll make a motion.
I'll second.
Any discussion? All in favor?
Aye.
Opposed? Carried. Resolution authorizing budget transfer of $255.67 from contingency A.1989.400 to payments to the treasurer to reduce tax. That would be Essex County Treasurer. A.1972.400, and that is the Geffner tax adjustment. Have a motion, please?
I so move.
Second. All in favor?
Aye.
Opposed? Resolution of receiving the letters from our two fire districts and Chilson Fire Protection District in regards to their letters approving the correction to the tax maps for each fire district.
I'll make that resolution.
Moved by Mr. Huntston,
I'll second it.
second by Mr. Taylor.
As far as impact, as far as, I mean, is it significant enough? Do we need to do a public hearing? I mean, is it going to adversely affect anybody a lot? As far as the impact of the...
No, and the reason for not holding the hearing is both fire departments are in agreement.
Okay,
That's why we did that.
okay. All right,
Won't change anything on the taxes or anything else. It's just,
okay,
It'll shift from one department to another.
okay. In terms of just coverage, you mean? Or tax?
Coverage and tax dollars.
Tax dollars, okay. And who gains and who loses? I should-
Chilson will gain somewhat.
I should know, I don't, okay. Good.
All in favor?
Aye.
Opposed? Resolution to insert the affirmative action policy section 801, page 800-1 to the Town of Ticonderoga Employee Handbook, and we have an attachment for that. Motion, please.
I'll move.
I'll second.
All in favor?
Aye.
Opposed? Resolution authorizing settlement of Article 7 real property tax assessment case commenced by Cole Lowe, Ticonderoga, New York, LLC, Lowe's Home Centers. We need a roll call vote for that, please. We need the motion and then a roll call vote.
I'll make a motion.
We have a second?
Second.
Second.
As far as, again, impact, is this going to trigger any special consideration within the 2015 budget year for the tax cap? I mean, is this...
Of course it will.
Yes.
Of course it will. Okay. Roll call vote, please.
Wayne Taylor,
Aye.
Bill Brunel,
Aye.
Fred Huntston,
Aye.
Patty Van Mark,
Aye.
and Dave is absent.
Now, we're going to move on to the next portion of our agenda, which is our committee reports. We're going to do it differently. We started this at county a couple of weeks ago. It's working very well. And in the interest of moving the meetings along faster, we have printed copies of the minutes for all the committees. The committee chairmen are going to be called upon if you have something coming up or something of note, please bring it to the attention of everyone here. Otherwise, we're really going to make our committee reports very concise and very quick to happen. And now, in response to that, I'm going off on a mile-long chase with Public Works. We have had a lot of very interesting developments in the Public Works area of our town in the last 30 days. We have had a meeting in regards to our water project that took place with Senator Little, Assemblyman Steck, the Department of Health, EFC, and other notables from the state and the town. There were statements made at that meeting that both our attorney and our engineers questioned. They were puzzling even to our elected state officials. We completed the meeting with a direction that we had to submit a report to the Department of Health. We knew that this report was necessary. Our engineers tried to submit the report once from the data they had available, and Department of Health refused to accept it and gave instructions to our engineers that were very puzzling at best. After this meeting, a gentleman from the Department of Health had a conversation with our engineers. Now, this is hearsay because I was not present during the conversation, but the engineer came away again with feelings of not being comfortable with the criteria that the Department of Health was putting forward for this report. Subsequent to that phone call, the Department of Health, the same gentleman, issued an email that was directed to several upper echelon people at the Department of Health. It was addressed to our engineer and our attorney, but no one as an elected official in Ticonderoga. That email directed our engineer to supply a report to Department of Health that indicated the Department of Health's position in regards to the Ticonderoga water supply, and instructed him to be sure that it reflected the Department of Health opinions in our water supply. Even though there is no factual data to allow the engineer to do this. The Department of Health insists that Ticonderoga be directed to use groundwater as a water source. We've tried to make Department of Health aware that we want to use the exact same water source, the exact same filtering process that is presently in use in Lake George Village. They completely ignore this concept and stonewall. We're interested, the town has voted and approved a project that would include Lake George as a primary source, gooseneck, and a well. Our engineer can definitely give a report about Lake George. It is a known source. The data for the filtering rates is available from Lake George Village. And he can design that. He can do the report for gooseneck. The water flow from gooseneck is a known entity. The data is available, and he could provide that part of the report. The well is incomplete. The well has a fractured casing and cannot be used in its present condition. There are many tests that need to be performed on that well before any of the same data, the flow rates, the quality of the water, and everything associated with that well, we know nothing about. But the Department of Health has said, provide us that report anyway. The engineer cannot figure out how to do that, quite frankly. And they have really put forth a tremendous effort trying to figure a way to get this done for the town. The big issue that they see is not being able to complete their job to do this. And I'll read from their letter. Is citing the standard general conditions of our contract, and that is a contract with the town of Ticonderoga. The engineer shall not be required to sign any documents, no matter by whom requested, that would result in the engineer having to certify, guarantee, or warrant the existence of condition whose existence the engineer cannot ascertain. Because of that clause, which is basically an ethical clause, you can't design mechanical systems by picking numbers out of the air. It's unethical. And that's what the Department of Health is asking these people to do. And they have resigned from this project. So we now have no engineer for our water project because of the actions taken and the demands made by the Department of Health. And it really puts the town in a very, very difficult position. I wanted the board to be aware of that. That's why it's brought up tonight. And, Mr. Fuller, myself, the engineers have spent hours trying to bring this to some kind of resolution and to bring out some kind of reasoning for the Department of Health to take the stance that they've taken. Can't tell you what it is.
Is that email that you referred to in here part of any of this?
No. It is available.
Yeah, we can give you any of that stuff.
We can give you a copy of the email if you want to see it.
But what is it exactly they're asking for that it isn't available already? You said that the data on Lake George is available, the data on Gooseneck is available. The only thing that's not available is the well.
Is the well, and that's what they want. They want the report to say that the well is the most economical, the most viable source that we have. We don't even know what the well will produce. All we have are estimates.
They've got right.
There's been no pump test done. There's been no five standard quality test done. There's, you know, it's just, the information is not there. You don't know how big the pumps have got to be. You don't know what the screen is going to be. You don't know the impact of you don't know the gallon flow out of that well. You know, you just...
I just would point to probably the number of extensions they've given us already. I mean, they have, in the background, the EPA they're the good cop in the room, and the EPA is the bad cop. And
That's one approach.
Well,
okay,
no.
I have a different approach to that.
Okay.
Okay, my approach is the EPA is going to be the good cop in the room,
well.
and the Department of Health is going to be the bad cop. Because if you, let me finish. If you take all the information that we've worked hours and hours and hours to put together, okay, there's no one that can say Ticonderoga has not been diligently working to get this system upgrade underway for the town of Ticonderoga. We believe we have a very viable plan to go forward with. The Department of Health is telling us they don't even want to talk about it. The Department of Health basically doesn't have the authority, in my understanding, to tell us what source we have to use. And that's what they're doing.
I'll bet you, though, you'll look in the New York State Assembly has adopted the standard general conditions in their contract, and then that 10 state standards. And I'll bet you in this 10 state standards, everything that they're prescribing is in that standard. That's what they'll point to.
The situation, I think, Wayne, the town finds itself in is groundwater hasn't been written off. I think the issue is that the well broke.
Yeah.
And that has set the town back. And we presented that to the Department of Health because we don't have that data. You know, we don't know what the flow will be coming out of it. We've got a pretty good estimation. But we don't know if it would impact, for example, a neighboring well. If it does, that's not Department of Health, that's DEC. DEC put a cap and number on how much water you can take from that well if you impacted a neighboring well, even just a little. Because they're never going to let you get to the point of impacting it. That's the discussion with the neighbors that come in. Lying in the background is DEC. You haven't gotten there.
No.
And so the directive was to prepare and file a basis of design report with cost estimates. And AES's concern is twofold. One, the town wanted to submit a basis of design report that included an option, not a project.
But supplanting information from a map plan report done in Lake George Village, right? Is that accurate?
No.
Okay.
What they wanted to do is include in that final, what the Department of Health was directing was that the basis of design report include budget figures and a proposal for groundwater. And AES's concern is we cannot do that without knowing what the yields are on this well. Otherwise, it's not a basis of design report, it's another preliminary report. They've already done that. They've already issued a preliminary report twice. And their concern is if you title it basis of design and you file it, then AES is going to be held to those numbers. And they're going to be held to that basis of design report. If something, we all know, be it taxpayers, the public, anyone, once something's in a report, a basis of design report, somebody gets a hold of it, they're either going to march in here and say, here's what you proposed, now here's what you're really doing. These aren't the same. You're going to say, well, that's because some things changed out in the field. No. This is a basis of design. This is your final. And similarly with Lake George, the town did make a request very early on. I wouldn't say very early on, but back in March, April, to include in the basis of design report an option for Lake George. You're correct, to include the same technology that Lake George Village is using. And the response was, not yet, it's preliminary. So again, getting back to AES's concern, their concern is they're being directed by the Department of Health to put their name and their seal on a basis of design report that would include a option for Lake George that they don't know they can use, and an option for the wells that they don't know they can prove. I mean, they're signing that thing at the end of the day. And I will tell you, we've had meetings where they've struggled with it. You know, they're certainly not interested in leaving the town in a difficult position. It's their reputation. They've got years invested in this. But at the end of the day, there is a significant concern on their side that if they do this and they put their name out there on this report and something changes, knowing that EPA could be coming, they're the ones that are standing there to have to answer for it. And I don't take that lightly. I put it in my position that if the Department of Health or DEC or some agency came to me and said, we need you to put your opinion, sign an opinion on behalf of the town that says X, Y, Z, and it's based on, you know, evidence A, B, C, but A and B haven't been proven yet, I'm going to tell you, I'm not signing that bond, or not bond opinion, but any opinion. I can't. So I think the reality is there needs to be an adjustment in the schedule to get the wells drilled. Those negotiations are ongoing with the contractor, Lane Christensen. It's not going well.
Okay. Now, initially, they had said they did not recommend that there's a change order here for the well driller. Okay, are they recommending that we do this now? Or initially, they had said...
Who's they?
They, AES. Or are they out of the picture now?
Those are negotiation points that we'll discuss in the executive session.
Okay, I gotcha.
So that is an ongoing claim with the contractor. That's why I was upstairs on the phone now. So the unfortunate thing I think that the town finds itself in is, you're right, many extensions were granted, and there were difficult decisions along the way that perhaps didn't get made, that ate up some of your time. But I think in the last year, you have made significant strides to come into compliance. The entire basis of design timeframe, I think, was derailed when that well got sheared off. Nobody saw that coming. Nobody expected, the town, Department of Health, anybody, that you'd shear that well off. And to ask anybody to include in a final basis of design, some design that, you know, you don't know how much water is going to come out. That'll dictate the amount of pipe, the size of pipe, the pressures that you're going to have, the pumps that you're going to have. It's just...
But as far as the Department of Health that's their final word on it was have it done with we're not giving you any more time?
Yes.
Yes.
Have it done by tomorrow.
Literally tomorrow?
Tomorrow.
Yes.
Okay. It isn't going to be done. Get the keys to the town ready, Bill.
I'll throw them again.
You can throw them at them.
I got them.
And I think that was AES's concern, is that, you know, a letter came out, issued with a 30-day time frame, and that was a discussion at our meeting, everybody knew couldn't be complied with. My understanding coming out of the meeting with Senator White and Senator Steck was that there was going to be some understanding on that time, that given the circumstances, the issues that we're having with the contractor, in getting that well drilled, that the town was going to have some time. That discussion with Todd and the engineer from the Department of Health made it clear that that was just a discussion on the phone, that the DOH was not going to give more time. I came away with the impression that they were going to. So that was a pretty significant change, I thought.
Everyone did.
And, you know, does it put the town in a precarious position? It certainly does. No question about it. Could expose us to enforcement and things like that, yes. Yep.
Well, we knew what the stakes were.
I think the well didn't shear off, you'd be in a much, much different position.
Absolutely. The well would have been up February, March. Should have been February or March. That's the bulk of my good news from the Public Works Department. We have other issues ongoing with the wastewater and the stream daylighting grant that are moving forward, albeit a little slower than we expected, but they are moving ahead. And, anyone else have any questions about where we are and what we're doing?
No, I
Mr. Fuller is going to be contacting Department of Health tomorrow. Explain to them the situation we're in, and falls in their court. They'll probably throw it right back, but, you know,
So what? We can't do it by tomorrow.
of course not. If AES had stayed on, it could have been done by tomorrow.
Right. And they're aware of the well situation.
Yes.
See, I mean, to me, I don't know if we should talk about this in open session or not, but I don't see who's going to force AES to seal prints with invalid information. We certainly aren't. I'm not going to vote for anything like that. And again, as a professional, you wouldn't be required to.
Right.
Okay, so, I mean, to me, this is a...
Maybe you should read the emails before you say a lot more.
They said, we submitted one basis of a design report that was rejected for those deficiencies.
Okay, but if it was me, I would keep working on something that would meet the letter of the law and give them what they wanted.
That's what they want to do.
Okay, well, what's the
That's what
problem?
AES wants to
They
do.
want to do, but we need to get the well in the ground and get that
Okay,
data.
well, let's get on it.
Well, that's what we're working towards, with DOH wanting it by tomorrow.
I'll tell you what, follow me around for a week and
Okay.
see if we're on it.
Wear your running shoes.
Works for me.
No, AES would, I think, would agree. We're all about the basis of design report in that complies.
Yeah.
The
But
problem
a
is,
resignation isn't...
you couldn't do it by tomorrow. And that was what you were
No,
being...
but I'd be working on it. When they came to cite me, I'd be working on giving them what they
There's
want.
no data to work with.
I know, Bill, but we got a change order here. Let's act on the change order and get the well drilled and get it rolling.
That's what we've been working on, Wayne.
I know, Fred.
But the point is they want it now.
But this is the first time I've seen the change order, any mention of a change order.
Oh, it came in this afternoon.
Okay, but that's what I'm saying. I mean,
That's
this
about as
should-
quick as we could get it to
I
you.
understand,
Thank you.
but it should have been part of the mix. Anyway, it
No,
wasn't.
If,
That-
okay,
we met
if
with
you
them last
have,
week.
I'll say this in public session. The rest of it concerns the dispute between the town and the contractor. Okay? But until you can get the contractor to the table, you can't get anything done. And you can't lead them any firmer, in my opinion, than we led them to get them to the table.
Okay.
This was as fast as we could get the contractor there.
Okay. And this was invoking what we talked about previously? You were going to picket something?
Yes.
Okay, and
Yes.
that's where this came from? Okay,
Yes.
Okay,
Yeah.
okay.
And the rest we'll let go until we get a session. Operation efficiency.
I do have next on your, this resolution about the New York State Environmental Quality Review Act determination of the sewer system improvements. Do you want to do that in your public works?
We can do that now if you'd like, yeah. It's the seeker, right,
Right, yes.
which came back negative.
Oh, no, we sent out our lead agency notice,
Right.
and then I have gone through and provided you an environmental assessment form that was marked up, that was part of your prior packet and application. And did you guys all got a chance to take a look at that?
Yes.
We did get comments back from the Department of Environmental Conservation, the SHPO, and the APA. The APA concurred with the town's designation of lead agency and just noted that the project was to bring more compliance into the long-term control plan. SHPO, not surprisingly, just identified various areas where we might have potential impact on historic resources, which we knew, and I believe as part of the GIGP and WQIP project, AES had noted and was working on. DEC responded and identified, that there are certain water quality certifications, a speedies permit, a stormwater pollution prevention plan, or SWIP. Stormwater management would be required, and also noted that the APA and/or SHPO may have jurisdiction, which we got letters from them. Turning back to the environmental assessment form, again, we did go through that. You guys have had a chance to review it. With all the questions that were answered in part 2 of the environmental assessment form, I don't think that any large or moderately large impacts from the project have been identified. For everybody's reference out here, the project that we're talking about is a grant application to alleviate some stormwater in the combined sewer system. We have what's called a CSO, or combined sewer overflows. What that means is we've got sanitary water that comes in from your houses, businesses, things like that, and stormwater that gets caught in catch basins on the roads. And our system is old enough that in areas, those systems are combined. And as you can imagine, during a rain event, that sends what is essentially cleaner water, falls from the sky, into the sewer system to the town sewer plant to be treated. So that bumps up the volume going through the treatment plant unnecessarily, because you're treating essentially what would end up in a lake or stream. So the goal of part of the project is to segregate or pull off some of those stormwater basins and divert that water into daylighting projects. You might see riprap and stones or man-made water areas, plants and things like that, so that that water can be pre-treated, get sand and salt and things out of it before it ends up in the river, most likely the Lachute. So that's the goal of the first project. And the other part of that, this overall project, is under our SPEES permit, which is the permit we've got to run the sewer plant. We've got various obligations as far as maintenance and new treatment. New regulations come down, and we discharge to the Lachute River, which ultimately ends up in Lake Champlain. So we have to comply with certain regulations under our permit. And so the other part of this project is to start enacting some of those changes so that basically we discharge cleaner water from our sewer plant to the river. So we evaluated the second part of this. So the step that we would take tonight would be to adopt the resolution that I drafted and sent to you that goes through the process. This is what we call type 1 action, meaning it could have a potential environmental impact. We coordinated with all the other involved agencies, the APA, DEC, Department of Health, SHPO, which is Historic Preservation Office, to solicit any comments that they might have, or to see if they wanted to be a lead agency. They didn't. This is a town project, makes sense for us to do it. And so what we do is we go through this environmental assessment form. The first part kind of identifies the project, different things about it, what we're doing, ground disturbance, things like that. The second part of it evaluates that data, and then we come to a decision of whether or not we think this is going to have a significant environmental impact. As I previously explained, the real essence of what we're doing here is trying to make things cleaner. We're trying to stop stormwater from getting to our plant, and we're trying to make the water that comes out of our plant cleaner. So, in reviewing that, I think what came from AES, the town's engineer, and what we've got in this environmental assessment form is ultimately really a finding that, it won't have a significant adverse environmental impact. So I've drafted a resolution at the board's request that goes through that analysis and adopts a negative declaration under seeker. So if you can read through it, again, you guys have had it. We've taken a hard look at all those things that are in there. We've had the resolutions from before, establishing us as lead agency, and now the one for tonight to make those, it's called a determination of significance. That's what we're doing tonight. And the recommendation would be to adopt that resolution, which again, just says that we do not believe that this project has the potential to have a significant adverse environmental impact.
Offer that resolution.
Second.
Wayne brought it.
Oh, I'll second.
Any further discussion? All in favor?
Aye.
Opposed? Carried.
And I do have the final form. We can do it after the meeting when there's a couple signatures that go on this form.
Right.
Goes in our file. I'll send a copy to the other involved agencies, and I also, it doesn't cost us anything, but we publish a notice in the environmental notice bulletin through DEC, so they'll take care of that too.
And then we're off and running.
We are. The next move,
This one, that it's in our packet, says that Dave Leon is present. He's not.
Yeah,
oh yeah, I just put this standard there.
I critique all that stuff.
The next one that's going to come up kind of quickly is the financing part of it. And I was actually talking with the bond counsel on it, Doug Goodfriend, back and forth by emails today. There may be a special meeting coming up at some point to keep the finance part moving along. He had some pretty big questions outstanding that I've shipped off to Todd Hobson, so I'll keep you guys all in the loop on that to let you know. And I also think we're probably going to have to go back to EFCA to get a couple of weeks. Doug seems to think he's not going to be able to get it all in. But I think I've already talked to Todd.
Well, their time frame was short to start with.
Yep.
And they indicated when we were in Warrensburg that, when we came up against some real significant time crunches, they'd try and work with us. So.
And we've done a lot of work, I think, in the last 8 weeks. We've been dealing with the water project, obviously, was the priority. And I think hopefully a couple of weeks in, this shouldn't be a big deal.
I don't think it will be. I'm hopeful.
We made some good
Do we
progress.
have any idea what the debt service is going to be on that bond for the for the wells up there? I mean, we just budgeted interest for this year, no principal payment, thinking that it was going to be rolled into that zero interest $11.9 million project.
Right.
But do we have any idea? We do not know.
Not at this point.
Okay.
Put that on the list to check now.
Now we can talk with Ms. Van Wert.
Wow. We had an Operations Efficiency Committee meeting on the 24th, and the discussion centered around the operation of the beach and the summer program, and we had 2 new councilmen assigned to that this summer, and it seemed like that it would be beneficial for council people to have, well, for council people and full-time staff to have written procedures that can be handed down from year to year in timeframes for what needs to be done and when things need to be done. So we talked about that, and we're going to be working on that. I'm getting those done from the people who have those jobs. The other thing we talked about a little bit, and from the prior meeting, was street lighting. And just as a bit of information, it seems like there's not a lot of good news tonight, but I asked for numbers for our electric usage over the last couple of years. And from 2012 to 2013, it increased our electric usage, our cost for electricity townwide increased 34%. And it looks like this year it's going to increase another 39%. That means $131,000 to our budget right there. And just as a number to consider when we're thinking about a 2% tax cap and things that we have to, things that we're going to have to deal with. So we'll continue to look at street lighting, areas where we might be able to save some. I encourage other suggestions as to how we can reduce some of these costs. I understand insurance is going up, so.
Chatty, did you have the list? There was a bunch of those that we downsized a number of years ago.
Yes.
You have the list of which ones?
I have a list of that. The problem is you can't determine what the list is telling you, where they're at.
Oh, I see.
Chatty, if you'd like to stop in someday, I can share with you some of the work that I've been doing on this.
Okay,
Because there's a payback time on the fixture. They change it.
I think it would be helpful if we're both on the same page, so to speak.
It would be. It would be. I'm just looking at an expense comparison control report.
Yeah.
And it's
how expensive would it be to put some LEDs in?
Big bucks.
Just a thought.
Yeah, well, those
I know
are things
it's-
that are,
it's
we
up
need to
front.
look at.
Those
are-
You know, what can we look at?
But we rent the fixtures. The fixtures belong to Niagara Mohawk or
This
National
is just
Grid.
electric usage,
Okay.
that's the
But
whole.
we're paying rental on the fixtures. We're paying, the usage is based on the average number of hours of daylight, and it changes. And that's why I said we pay whether the lights are on or not. So if they're out, it behooves the town to have
We
them.
did do a
repaired.
study on that. Chief Johns did a survey to discover what was off and what was on. And that, a good share of that has been addressed. I don't know if they've got them all yet, but they were repairing them.
39% increase, Shadi?
That's overall, that's not just street lighting, but I.
That's overall cost.
That's overall for electric for the whole
We've got to
town.
look hard at that.
That's
a
sewer and
40
water, that's buildings,
That's
that's
a
everything.
40% increase.
Now, is that before or after they unplugged Vermont Yankee across the pond over there?
That's to date. That's just what, I looked at what we've spent so far this year and just did a monthly breakdown. And if we spend the same amount for the rest of the year, it's going to end up being $131,000 more than we spent last year, which is 39%. That's, it's rough, maybe our usage is going to be less. I don't think so. We've got, some cold months coming up, so.
We can just put lights on the falls.
Where do we use electric heat? At the water plants, we use electric?
I don't
Anyway,
know.
we'll talk about it at
Yeah.
your next meeting.
Just as a point of something else for Wayne to worry about.
No, I'm not worried.
No,
No, I know where.
no, it's just, that's,
There's no such thing as debtor's prison.
that's all.
Thanks, Betty. You get to keep going with buildings and grounds, parks and recs.
Oh, okay. It's not here. Well, I think we made a lot of progress with getting projects done. I think the parks are looking good. We decided that we won't be trying to remove the oil tank at the Armory this year, that since we passed inspection, it's good for another couple of years, so we can put that ahead to 2015 or 16, I guess, something like that. Transferred some trucks, a truck from one department to another. And there's still, we've got a lot of miscellaneous projects, some smaller, some bigger than others.
Are we converting the boilers at the Armory to propane?
Not now.
We're looking at it to try and get costs
I see.
associated with it.
Right now, they were just staying with what we have until we have time to
Okay.
look at other things. The minutes are here, and the project the project status report is in the packet as well, if anybody has any questions about anything in specific.
I'd like to compliment buildings and grounds, particularly the grounds crew this year. Both the committee and the crew have really put in a tremendous effort. It's nice to see that kind of commitment from volunteers and employees to work together and get the amount of work done that they have.
Well, and
Thank you.
one of the things that I'd like to do is to, and I haven't gotten around to it, is to write like a press release about all of the parks that the crew does maintain. There's something like 26 locations. And the other thing I would like to ask, if there are any neighbors living next to these parks, if there's any part of that maintenance that they'd like to do, whether it's flowers or trim the bushes or water or rake or whatever. We do have one resident who helps maintain one of the parks, and it really is a big help. It makes you look better.
Yep.
We're not putting anybody out of work, we're just making the town look better. We depend a lot on the garden club. You'll see a couple, especially 2 members of the garden club out there almost daily. And it would be nice if we had a little more residents, a few more residents doing things like that just to help out. So that's on my to-do list, I just haven't gotten to it.
Well, don't stop, you've got economic development too.
Oh, okay.
You're doing a good job, you're on a roll.
The Economic Development Committee decided that we wouldn't meet in July and August, but just as a couple of points of interest, best fourth, I think we had the best fourth ever. Not that that's an Economic Development Committee, but, you know, we participated in that. I heard great things from everybody about how good the fireworks were and how many people attended. Same thing with Street Fest. We had more music, more food, more visitors. So those two summer events went very well. The North Country Community College is still working on their RFP, and I just say that because people ask me, is the College of Applied Technology, or do we lose that, or is it still possible? And it's still possible. They're working on an RFP to do a feasibility study on that, and that should be out in September. We met about streetscape, and the consensus is that we're not going to do any redesigns of any plans. We're going to continue to work on cleaning up our appearance downtown and everywhere throughout the town. Lights, everywhere from lights that aren't lit to trying to get property owners to clean up their properties. And that's at all levels. It's certainly downtown, but it's also throughout the town. And I attended a meeting. The Destination Master Plan is a regional plan that we're working on. We're working on it with Crown Point, Mariah, Hague, Putnam, and Tye. And we just met today at the fort to look at the new things that the people are doing, that the fort is doing. Their visitation is up. And that's a big part of our regional economic development plan. And if you haven't been to the fort in a couple of years, I encourage you to go. There's a lot of new attractions. And that's it.
Very good, thank you. Airport. Mr. Huntsman's got an item he wants to bring up for the airport.
Yes, we have been told by FAA that, well, I'll read what they actually said. A proposal to close an airport temporarily for non-aeronautical purposes must be approved by the Secretary of so on and so forth. Grant issues and 19 operation maintenance requirements airport supporters to not cause or permit any activity or actions on the airport which would interfere with its use for an airport purposes. Otherwise, we would have to give back all the grants and so on that they have given us to more or less build that airport and put it in production. We had a meeting on the August 5th at 9 a.m. Present were Dave Uliano, Fred Hunston, Ernie Tobin, John Hanna. FAA representative was there and talked with David Uliano, and he required that we need more, or indicated we need more lights on the runway. That is included in the fuel farm presentation that it's ongoing.
Was it?
We would get for that?
It's part of fuel farm grant, correct?
Right. There was a.
I would assume that was pointed out to the gentleman.
Yes. Yes.
If they would release that grant money, they'd probably get the lights.
Exactly.
Yeah, okay.
Excuse me. There was a pilot that brought up water. They would like some water there to wash their planes, and also it was brought up in the meeting about being a safety factor for if there was any fires or anything there. We discussed that. We talked about access to the airport, which I just read on that principle. The technical, we set up a technical advisory committee, and there's a a slew of names, which I don't have right here. But anyways, they oversee the operations and so on, and what we do and so on the airport. That's about all I've got on the airport.
Very good, very good. Highway?
We did not meet in this month. We did not have a meeting. There were some scheduling issues, and we couldn't get all the players to the table. The highway meeting will be held at 5 p.m. from now on, to necessitate, or out of necessity for some of our members that need to be able to be there and still maintain their jobs, so.
That'd be a good thing.
Yeah. They are paving. The paving is per the list that was submitted earlier in the year, to the tune of, it's going to be around $300,000 worth of pavement. It's been put down, or will be put down one time they're done, so.
Does it appear that they're going to stay within that budget with the amount of pavement that they've got prepped and ready to go?
What they got prepped and ready to go was in the original proposal that they made. Each of the streets, the Schuyler Street, Treadway, Warner Hill, Wiley, Shanahan, they were all part of it.
And it appears they're going to be within that budget.
So you're changing tonight your official time for your highway meeting's going to be the same?
It will be,
the last
it'll be the same day as water sewer, but it will be at 5 o'clock in the afternoon,
Starting in August?
starting in August, yeah.
It won't be this month, but it's all right. Because we moved water and sewer to the 28th.
Okay.
But you did water and sewer, but you didn't move highway.
Well,
No.
we'll leave highway,
That's why I say, and it won't be the same day in August. It'll be,
it'll be different.
Oh,
yeah,
well, it's still the last, yours is still the last Tuesday
yes.
Last Tuesday, yeah.
at 5 o'clock.
Yep. That's all I got.
Okay, Human Services, Youth and Seniors.
Okay, we didn't have a seniors meeting. They called that off last month, and then we won't have one for this month because the acting president, the treasurer will not be there. The only one will be there will be the secretary.
Yeah.
And we decided that that wouldn't be a very substantial meeting.
Okay,
The Youth Committee meeting, called to order at 5 p.m. Present were John Bartlett, Tanya Thompson, Chatty Van Wert, and Fred Unston. Discussed the qualifications for lifeguard. One is that they have to recertify every year in CPR for the health department. Excuse me. The problems with the youth problem are very hard to get to the bottom of without the directors coming to the meetings. We have discussed this, we had a special meeting on it, and we're hoping we're putting together something that will, matter of fact, Chatty had something in her report on it also. The committee went over some of the problems, and we're hoping to, we should get it rectified to where we can keep a closer track on it, and people will be responsible. We've got to bring our directors and so on board earlier than we have been. And that's a resolution I would like to make for the soccer director, which I would like to submit Tabitha Woods for the director. For the soccer program, correct.
Resolution, we have a second?
I'll second it.
Second, any discussion? Has she had this position before?
No.
Who handled it before?
Lacey LaCourse handled it last year, the Pikes handled it for the 3 previous years before that, and Shelley Young held it for the last 15 years before that.
Was it advertised?
Yes.
It was, okay.
Tabitha handled what last year?
She's handled T-ball.
T-ball and so on.
That's been involved for a long time.
Yeah.
And his budget, Fred, the money's, there's a line item for it.
Any further discussion? All in favor?
Aye.
Opposed?
And that's what I've got on youth.
Okay. Public safety, we'll wait for Chief Jones. Library, cable, TV.
Nothing to report.
Nothing to report. Board of Health, we have nothing to report this week, or this month. Insurance committee.
Yeah, we did have our meeting on the 12th of August. Our representative, Mark Crawford of Burn Financial, came down and just gave us an update. There's a lot of stuff about our insurance is still in flux, but they did tell us that we are part of what's considered a mid-segment of experience-rated communities right now, and the fourth quarter renewals for 2014 are coming in at 13.2%. That's with Excellus Blue Cross. We did just do some preliminary number crunching in terms of what we pay currently, and the town of Ty right now pays out $408,000 a year on health insurance. And at 13.2%, we're looking at an aggregate increase of $53,040 going into 2015. So that's just food for thought. And pretty much they did schedule the next meeting. It's going to be in October. I think it's October 9th. I'll get that to you, Donna.
That is the date, I think she said that it was going to be rescheduled.
Yeah, October 9th. So it'll be the next meeting, and he said he'll have some firm numbers for us in terms of what the rates are going to be for next year. Other than that, it was pretty good meeting. There's a lot of things changing. There's more mandates that are going to come to bear as a part of the Affordable Care Act in 2016. There's going to be a number of things that it may provide us with more flexibility, some different options we might be able to offer, maybe by getting back into a community-rated system. However, right now with community rates, the renewals right now, they're higher than what ours are. Right now, they're 16%. And like the town of North Hudson, the town of Scroon are considered community rated, and that's what their increase is for 15. So anyway, that's all I have.
Very good. Contract negotiations, we'll wait for executive session. Reports of department heads, we'll start with Mr. Fuller.
I think we've hit most of it.
I hope so.
So one thing I did send up to you, we talked about the last couple of months was the insurance local law. Not that's something we want to throw on the table now, but just to give the town the ability to intervene in insurance settlements for fires and things like that. Basically another tool in the toolbox for dealing with burned out properties.
I was going to save that for the financial meeting because I really haven't had an opportunity to review it completely, and I'm sure the board hasn't either. I don't think I've forwarded it yet to the rest of the board. So.
That's completely fine. Well, we dealt with. Yeah, we dealt with everything.
Very good. Chief Johns.
Public Safety Committee met on July 28th. Just in keeping with your instructions, I'll go over a few of the major points. We have no request for resolutions or motions by the board. Under code enforcement, major thing discussed was convening Board of Health, the town board, and also nuisance property action that was taken earlier today. Request for town council is that last night there was an arraignment for the litter law violation. No problem. Last night there was an arraignment for the litter law violation that was issued at 163 Lord Howe Street. The local criminal court, I believe, was a little confused because we have Department of Health issues and there's some property issues going on through the town board, where the town council, acting as the prosecutor of that action, I would just ask that you contact the local criminal court and let them know that that does not remove criminal sanctions for violations of that proceeding, and that should continue.
You know what judge that's before?
Judge O'Brien. He just adjourned it because he wasn't sure whether the town board was taking it out of his hands. I believe you'll agree that the actions of the health board and the town board does not remove criminal sanctions of the law violation.
Yeah.
Under police, budget season is approaching, and the committee is going to start having some discussions about how the town police department can come in with a 0% increase in the 2015 budget and possibly start looking at a capital project for proactively going after some of the drug issues locally. It's going to be some interesting discussions in our future meetings. The other thing that we're going to start discussing in our August meeting is we're seeing some great concerns with the number of taxi cab companies that are springing up in Ticonderoga locally. We're going to start discussions on what many municipalities do, that being coming up with a local law requiring that these taxi companies apply to the town clerk office for medallions for those taxi cabs, and also permits being issued for people who drive those taxi cabs, just to make sure that they are safe and qualified drivers. The New York State Department of Motor Vehicles does not have any testing or requirements to obtain a Class E license. You just have to show up, pay a certain fine, or certain fees, and no issue.
Freudian slip.
Very unsafe driver, that Class E license. So municipalities all over the state are seeing this as a safety concern for their citizens, and just want to get a little bit of regulation on very unregulated business. And the Public Safety Committee is going to start talking about those medallions and operator permits for taxi cabs. The local drug coalition had a very successful and well-attended town hall forum on Tuesday evening. It was well received by the people who did attend, and I do thank the town board members who did attend that for showing up and showing support for the drug coalition. The next meeting for the Public Safety Committee is August 25th at 5 o'clock p.m.
Very good, thank you. And last but not least, our town clerk.
The one thing, so much going on here. We did have the public hearing on that.
Splitting a nap or what?
Yeah. We did have the public hearing on the amendment to the building code, local law, but we did not actually adopt the resolution. So if somebody can introduce and adopt that resolution adopting the local law, that would be great.
I'll make it.
Moved by Mr. Huston, second by Mr. Taylor. Any further discussion on the issue? All in favor?
Aye.
Opposed? Mr. Ball has his,
Got it. Whole toolbox.
open the door. Well, no, it's not a full toolbox, but it's getting there.
You have interfund advances to do. Do you want to do them, or you want me to go through them?
Go ahead. I don't have.
Interfund advances to be adopted per general municipal law 9A for abstract 8, 2014. Number 1 is from general capital project central sewer improvements, age 23, for $20,876. Funds will be reimbursed with the EFC long-term financing. And your second one is from general to the GIGP daylight streaming grant, age 49, for $27. Funds will be reimbursed with grant monies for that.
Have a motion, please?
I'll move it.
Second? Any discussion? All in favor?
Aye.
Opposed?
Just on a side note, is AES going to still be involved with the capital plan or the
Yes.
project? It's sort of.
Yes.
Okay.
Okay, some miscellaneous notes that I wanted to bring up. Just for information, Hudson Headwaters bus, which is owned by Hudson Headwaters and run by Interlakes, has been abandoned. And it has put some of our citizens in a predicament. I want you to know that the county and the town are trying to get to the bottom of the issue, and then we will be going to the state and federal to see if we can get funding, because we need this bus in Ticonderoga. One other thing I kind of wanted to bring up was something to think about is we have some of our department heads that come to our board meetings. And what I'd like to do is have the department heads attend, all the department heads attend all the board meetings. We will organize the reports of committees so that the department head committees will come up first. We'll do public works, we'll do highway, and so on, to get those people. Once the committee report is done, they can be released to leave. But if there are issues that come up during the meeting that we need them here, I'd like to have a policy. I don't know that we need a motion particularly, but we do need to establish a policy that states that. And we'll get that written. We'll have it present for the next meeting, and then we can go forward with that situation. I think it'll be better for everybody. We do have an issue of negotiations. We have two issues of negotiations that we need to have a short executive session. If someone wants to move that, we can get that done and get out of here at a reasonable hour.
I'll make a move.
Excuse me. Any public input before we go to executive session? Is there anyone from the public that would have something they want to bring up?
Yes, sir.
Yes.
This past summer, out in front of my ice cream shop and out in front of this beautiful building is a lot of drug sales right out in front of my ice cream shop. And it's a public safety issue. There's children, all kinds of people going through there, and it's done in front of the shop, going down into the park. And I know the police force can't be everywhere, but it's just not good for a family-owned business. And it's right out in the open.
I'm sure that has been well noted by gentlemen sitting here in a uniform.
I understand that.
And, if you brought it to anyone's attention,
Yes, sir, I have.
you have.
Yes, sir.
All right. I know that direction has been given to our chief, and I've seen, not in all areas, but in many areas, that there has been an improvement in that type of situation. I'll bet there'll be an improvement in this one also.
Who's the gentleman?
Would you stand and state your name, please?
My name is Jim Cannon.
Yes.
Thank you.
Okay, thank you. And you own the ice cream shop next door?
Yes, sir. And numerous nights I've lost many patrons because of the problems upstairs in Abishans and going back and forth from the park, and young people passing dope right in front of the ice cream, broad daylight, and it's just not good.
Point
This
taken.
isn't a city. This is a little town.
Point taken. Anybody else have anything they'd like to bring up? In that case, I'll take a motion to move to an executive session.
I'll make it.
I'll second.
All in favor?
Aye.
Opposed? Thank you for coming, everyone.